Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a short docket for you today with one subject on it. That's right. It looks like Lori Vallow wants a continuance as well. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich. This is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell so you receive notifications of when we go live or put up new content. And remember, we're doing a short docket today because it's Tuesday, which means we're going live tonight, 6 p.m. Mountain Time. Join us here. All right. Let's get to the docket. First thing, Lori Vallow wants a continuance. A motion that was filed yesterday by Lori Vallow's attorneys basically states, well, let's talk about it. The attorneys for Lori Vallow, Jim Archibald and John Thomas, filed a motion to continue the trial, to toll time limits, and to stay the case. Now you may say, Scott, what the heck does that mean? Why do they not want to go to trial? Well, let's talk about it here. They state in their motion, trial is currently set on January 9th of 2023, and a final pretrial conference is set for November 9th of 2022. The time limit to file written notice of our intention to raise any issue of mental condition under Idaho Code Title 18 is 90 days before trial, or October 11th. And then in a big redacted paragraph, they state what they want to do. Of course, that's been redacted, so we don't get to see it. And then in the final paragraph, it says, because of big redaction, the defense asks for the tolling of the time limit in which to comply with the pretrial orders, a continuance of the pretrial date, and a continuance of the trial date. Now, being the inquisitive people that you are, you may say, Scott, what is applicable under Title 18 of the Idaho Code? Well, we have pulled that relevant section for you, and that is Title 18-207, it's crime and punishment of the Idaho Codes. And what it says is mental condition, not a defense. And it says specifically under paragraph 1, mental condition shall not be a defense to any charge of criminal conduct, which is basically their way of saying we don't have not guilty by reason of insanity. However, like all statutes, you must read on. And here it says, nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind, which is an element of the offense, subject to the rules of evidence. So what does that mean? It basically means, hey, you can't run NGRI, not guilty by reason of insanity. But if somebody has some sort of mental disease or defect, guess what? It can go directly to their state of mind. Remember, in any criminal offense, you must be able to show, the prosecution must be able to show, that the conduct was done knowingly. You knew what you were doing. You were aware of the conduct. You appreciated the circumstances of the event. But if you're crazy, guess what? You're not going to be able to show that there was that mental intent. And what do we know? We know that Lori Vallow was not competent to proceed for some 10 months. The real question is, when did that basically not being competent begin? Was it when, I don't know, she's allegedly involved in the killing of her ex-husband in Arizona? Was it when the kids disappeared in Idaho? That is a question of fact for the jury to decide. And so, where is that information going to come in? Well, medical records, right? The medical records and evaluations that took place. And so why is this hearing important? Well, because under the statute 18-207, paragraph 4A, notice must be given at least 90 days in advance of trial that a party intends to raise any issue of mental condition and to call expert witnesses concerning such issue, and failing with such witness shall not be permitted to testify until such time as the opposing party has a complete opportunity to consider the substance of such testimony and prepare for rebuttal through such opposing experts as the parties may choose. Well, guess what? When competency was raised, and different, there's a difference between competency and suffering from a mental disease or defect, but they usually run hand in hand, okay? And so As you may recall, way back when the competence issue was raised and the report came in saying that Lori Vallow was not competent to proceed, the prosecution confessed the motion. They said, yeah, you're right. We agree. She's not competent. It'll be interesting to see if the prosecution uses this time, which is permitted under the statute, to come up with their own expert to say, well, she really wasn't that crazy. She understood, she appreciated what was going on. So it is now going to get interesting. Bottom line, though, is I don't think we're going to have a trial in January when you consider this request with the request of Chad Daybell through his attorney, Mr. John Pryor, basically, as we talked about yesterday, go check out the video, who basically says, Judge, I'm not prepared. I would provide ineffective assistance of counsel to Mr. Daybell if I was forced to go to trial on January 9th. One other motion was filed, and that was a motion filed by the Idaho Department of Health and Welfare. And basically, it's in response to being an interested party in regards to the motion filed by Lori Hellas. And it states, the department understands the relief requested in the motion of non-party movement to unseal court documents and transcripts or recordings of past hearings and is not proposing any further action by the department at this time. Basically, what they're saying is as an interested party, we don't intend to interfere. We're going to leave it completely up to the court. So maybe, just maybe, we're going to get some more access to what's really going on. And I stress how important it is for the courts to be open and transparent with the public in this particular situation. And I understand there are certain things regarding mental health issues that are probably not going to be released. But just think, ladies and gentlemen, the motions that we've been talking about have gleaned more information about what's really going on in this case than what the court thus far has allowed us to see. So hopefully we're starting to see a bit of an easing of some of these unduly burdensome restrictions in this case. All right, that's all we have for you today. Thanks for watching. Remember to join us live at 6 p.m. Mountain Time. Hope you're having a wonderful day, not just a good day. We'll see you next time.